Hello, I'm Dr. Ben Hudson and I'm a lecturer at the University of Exeter. I lecture in areas such as international human rights law, public international law, environmental law and property law. I'd like you to think about the following questions. How do we know where one country ends and another country begins? Who has the right to exploit the resources that can be found in the ground beneath our feet, in the seas that flow around us, or in the space that exists above us? Who is responsible for ensuring civilians do not come to harm during the course of armed conflict? And who should be held accountable if they do? Who has the right to live and work in a particular place, and under what conditions? And how do we respond to the impacts that a changing climate pose to the places we call home? To be able to answer any of these questions, we inevitably need to engage with public international law. As Martin Dixon, Robert McCorquodale and Sarah Williams explain, quote, "International law is really a description of an entire legal system. It is an international legal system by which legal rules are created in order to structure and organise societies and relationships." End quote. Public international law is vast, and even if we might not realise it, is immensely important for all of us in our daily lives. At the heart of public international law lie states. We see their presence, we see their influence and their power when we look today at the bodies of the United Nations, the UN. The General Assembly is comprised of the member states of the UN, plus a small number of observer states and eligible non-member states. When we look at the Security Council, all of its 15 members are UN member states, 5 of which are permanent members, that is China, France, Russia, the United Kingdom and the United States of America, and 10 non-permanent members that are elected by the General Assembly for 2-year terms. And when we look at the International Court of Justice, which is the principal judicial organ of the UN, it is states that are entitled to appear before the court. The judges on the court, while not representatives of their governments, are elected to office by the UN General Assembly and Security Council, which, as we know, are comprised of states. Moreover, much of the substantive content of international law, its treaties and its customs, concern the rights that states have, and the obligations that they, states, have to each other. However, public international law is not only about the relationships between states. Since the middle of the 20th century, we have seen a new development. That is, the emergence of the individual as a subject of international law. As we know, the year 1945 marked the end of the Second World War. 1945 was also the year that the United Nations was born, established by the UN Charter. While the Charter refers to nations and to states throughout, it also, from the very outset, speaks of faith in fundamental human rights, of the dignity and worth of the human person, and of the equal rights of men and women. The Charter really set in motion the development of what we today call international human rights law. Indeed, one of the 4 stated purposes of the United Nations is, quote, "to achieve international cooperation in promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language or religion." End quote. Yet the Charter itself says little about any specific human rights. It is the 1948 Universal Declaration of Human Rights where we first see a list of human rights and fundamental freedoms. These include, for example, the right to life, liberty and the security of person in Article 3, the right not to be subjected to torture or to cruel, inhuman or degrading treatment or punishment in Article 5, and the right to education in Article 26. While the Universal Declaration of Human Rights is a pivotal document for its aspiration and ambition, it is important to note that it is declaratory. This means that it is not legally binding in and of itself. The foundational human rights treaties at the UN level are the 1966 International Covenants on Civil and Political Rights and on Economic, Social and Cultural Rights. These two covenants came into force in 1976. They are therefore legally binding upon those states that have agreed to be legally bound by them. This means that a state that has ratified the International Covenant on Civil and Political Rights cannot, for instance, interfere with an individual's right to freedom of expression unless there is a treaty-compliant reason for doing so. While these two covenants are foundational at the UN level, it would be incorrect to assume they were the first of their kind. This is because, over a decade earlier, in 1950, the European Convention on Human Rights came into being, coming into force in 1953. Yet, as its name tells us, the European Convention on Human Rights applies only to states on the European continent, not globally. But we do have similar human rights treaties that have been enacted in other regions of the world, namely the American Convention on Human Rights, which legally binds many states across the Americas, and the African Charter on Human and People's Rights. Now, if we think back to what we said earlier about public international law not only being about the relationship between states, well, human rights law veers away from the traditional state-to-state dynamic of public international law because it predominantly concerns not the relationship between states, but the relationship between the state and the individual. We say that international human rights law acts vertically between the individual and the state, as opposed to horizontally between states. Now, that's not to say that we never see this horizontal state-to-state dynamic in action in international human rights law. We do when one state brings a case against another state. Take, for example, the cases that have been brought to the European Court of Human Rights by Georgia, by Ukraine, against Russia in the context of armed conflict. But there is only a very small number of these interstate cases. Moreover, even though these legal proceedings are between states, the state that is bringing the case is doing so on the basis of alleged violations of individuals' human rights. In other words, the individual is at the heart of the case, and it is the individual that is at the heart of this branch of public international law. In the decades since the International Covenant, there has been a proliferation of human rights treaties, as well as courts, commissions and other bodies associated with these treaties. We have UN treaties on specific issue areas, for example on the prohibition of torture and on protection from enforced disappearance, and UN treaties that concern specific groups, for example on the rights of the child, on the elimination of all forms of discrimination against women, and on the rights of persons with disabilities. We have also seen international human rights law reaching into new issue areas through the courts. Climate change is an excellent example here. The European Court of Human Rights has ruled that a link exists between human rights and climate change. In the 2024 case of Klimasenioren and Switzerland, the court said that the rights contained in the European Convention on Human Rights, including the right to life in Article 2, can, quote, extend to complaints of state action and or inaction in the context of climate change, end quote. This is really important as a development because there is nothing explicitly said about climate change or the environment in the European Convention on Human Rights. In the Americas, in July 2025, the Inter-American Court of Human Rights delivered an advisory opinion on the climate emergency and human rights, in which it states that there is a human right to a healthy climate, which, while derived from the right to a healthy environment, exists as an independent right under the American Convention. This expansion of international and regional human rights law is remarkable. However, it does not mean that everyone now enjoys their human rights in practice. We need only look at the news channels to see that this is far from being a reality. As important as these treaties and judgments are, to realise human rights protection, we need much more than just words on paper. States need to act to ensure that human rights provisions are actually implemented on the ground. And we cannot assume that implementation will automatically follow the ratification of a treaty or the handing down of a court judgment. Human rights implementation requires much more targeted attention than it has received to date. Plus, it requires resources, vigilance, and a faithful and enduring commitment to human rights norms and values. Furthermore, if it wasn't apparent before, it is now abundantly clear that the progressive development of human rights is not something that we can take for granted. While on the one hand we see human rights courts expanding into new issue areas, such as climate change, on the other hand we see certain groups of individuals being subjected to restrictions on their human rights. Typically, it is those that are the most marginalised in society, such as those who migrate or who have been displaced within or across borders, who find themselves excluded from this mainstream human rights protection. It is surely the case that such restrictions and such exclusion are at odds with public international law's stated aim of respect for human rights and fundamental freedoms for all without distinction. Yet this reminds us of something very important about international human rights law and about public international law in general. As Dixon, McCord, Cudale and Williams tell us, public international law is a system by which legal rules are created. But who creates these rules? Well, it's states that create these rules, and it is states themselves that decide whether or not they will abide by these rules. As Louis Henkin famously said in his 1979 book, How Nations Behave, quote, "Almost all nations observe almost all principles of international law and almost all of their obligations almost all of the time," end quote. International human rights law in its current form only exists because states have made it so. States are only bound by human rights treaties because they have consented to be bound by them. Human rights courts are only able to deliver judgments against states because those states have consented to the courts doing so. Essentially, individuals only enjoy the legal protections afforded by international human rights law because states say they do. In sum, even though international human rights law has made the individual a subject of public international law, public international law remains a system designed by states with states and their interests at its centre. Thank you so much for listening. I hope you found that really enjoyable, and I look forward to, fingers crossed, seeing many of you at the University of Exeter in the future.